Okay, so we're back now for part two of our chapter 8 lecture, again talking about law and legal professions. And remember, we talked a little bit about the perception of lawyers and how they're kind of viewed, and a couple of laws that kind of come to light we're going to talk about now. So first would be the case of Gideon versus Wainwright. And here the Supreme Court held that the Sixth Amendment guarantees that in the book they use a term called indigent, but it just means poor. Criminal defendants receive legal representation, and it's estimated that in recent years about 80% of all criminal defendants utilize publicly funded attorneys because of the fact they can't afford a private attorney. And so this is important because, as we talked about the fact that attorneys had the perception of being, they weren't satisfied with their job. They wanted to be, in those private firms with lots of money, etc. And they didn't want to work in general practice, family law, or as criminal defense attorneys. But the majority of people that need those folks are ones that can't afford an attorney. So that's the importance of the case, or one piece of importance when it comes to the case of Gideon versus Wainwright. And there's other aspects that are important as well, because it kind of feeds into the next topic where we talk about the criminalization of poverty. Now, the Department of Justice investigation of Ferguson, Missouri's police department didn't find any racial discrimination in the police force, but it did find that the city's revenue was largely based on funds from things like petty arrests and fines, and mostly from those who were already poor, and most of these individuals were African American. So there kind of seems to be an emerging discussion in this country about this criminalization of poverty. So, again, as I kind of said, municipalities have begun to utilize the criminal justice system in a way as a revenue stream by turning court personnel into debt collectors. Now, that might seem like a little over the top, but when you talk about criminalization of poverty, it's not exactly that bad, but it's starting to kind of push in that direction when you talk about it under this type of issue. When fees from offenders are necessary to fund city services, there's no incentive to reduce crime. That's one thought, but kind of, a little bit more, it seems that after the recession in 2008, again, large and small municipalities began to utilize this system to help offset some revenue. And police officers would write tickets and make arrests for even, minor misdemeanors, etc. Prosecutors would enforce those, and then judges, of course, would assess fines and court costs, etc. So that's how you could probably get that kind of viewpoint, right? And the bigger problem here is that if, poor people can't pay the fines, then they incur even heavier financial penalties for non-payment, right? Which then leads to the possibility of jail sentences where some, locales, they're charged for even medical care and some necessities that might even leave them with more debt. So you do have to kind of look at the whole process as a whole. And again, the study, when they did the study of Ferguson, Missouri, they really did see that the poor were subject to unfair fines, driver's license suspensions, and things like that. So today advocates are, again, kind of pushing jurisdictions to consider what we call pretrial releases for low-risk individuals, right? Municipalities are looking for ways to kind of raise revenues in current times, whether it's fines, fees, court charges, or, even failing to pay. And, opponents of this pretrial release, including the American Bail Coalition, argue that pretrial release runs the risk of individuals not showing up for court dates, and the use of risk assessment instruments is expensive. Now, opponents of this pretrial release point to research that also shows that those who are bailed out have a higher appearance rate than those who are released on personal bond. And then, some other recent studies kind of show no significant difference between all of those. So it is kind of something that's interesting, and we really do have to kind of look at it. But, again, across the country, it does appear that municipalities, counties are kind of looking for new ways to raise revenue, possibly using, the criminal justice system as one of those avenues. And then one kind of real quick case to kind of talk about an extremely pervasive issue across the country seems to be poor people being jailed for non-payment of things like court costs and fines alone. Now, the problem with this is that it is in fact unconstitutional to have what is in effect, kind of a debtor's prison or jail. So the Supreme Court, in a case called Tate versus Short in 1971, and then a second case called Bearden versus Georgia in 1983, these cases ruled that individuals can't be jailed for not paying fines or court costs unless there is a determination that there is an ability to pay and the non-payment is willful, meaning that you can pay, you just don't want to. Otherwise, they can't really put you in jail for something like that. So, and a lot of other programs came along. I mean, in 2015, California instituted an amnesty program for drivers with lesser infractions, allowing them to pay 50 or even 80% of what they owe, depending upon their income. So a lot of different things are kind of coming about as it relates to that. Okay, so kind of moving on, we're going to talk a little bit about what they call courtroom work groups, and we're still in the law and the legal profession, under that umbrella. So Blumberg in 1969 and Scheingold in 1984 refer to the practice of criminal law as kind of a confidence game, because the prosecutor and the defense attorney conspire to appear as something they're not, meaning adversaries in a do or die situation. Now, what is more common is that the prosecutor and defense attorney will still be working together when that client is actually gone. So attorneys may display adversarial performances in the courtroom, but, that show, if you will, is only if the jury is in the room. Okay, typically does that happen when they're not? And kind of adding a little bit to that, just so you know, defense attorneys, judges, prosecutors, they do work together every day, and they often even socialize together. So there's kind of a question there. They may even be married to each other. So these are things just to kind of consider when you talk about relationships between those main players or actors in the criminal justice system. And then you have the term bureaucratic justice. So another perspective describes our courts as administering bureaucratic justice. In each case is only one of many for the professionals who work in the system, and the actors merely follow the rules and walk through the steps. And so the goal of the system, namely, bureaucratic efficiency, becomes more important than the original goal of justice in the first place, right? So, and that's not a good thing. Also, because each case is part of a workload, decision-making takes on more complications. So, for instance, a defense attorney may be less inclined to fight hard for a kind of a loser client, if you will, if the lawyer wants a favor for another client later in the week, and the prosecutor may decide not to charge a guilty person to get him or her to testify against someone else. Now, in this sense, each case is not tried and judged separately, but is linked to other cases, right? And kind of processed as part of a workload. And, the bureaucratic system of justice involves procedures and policies that, although not intentionally are discriminatory, they may contribute to the perception of fairness. And then, kind of finishing it out, when we talk about plea bargaining, okay? Plea bargaining is consistent with the bureaucratic type justice system because it is the most efficient way of getting kind of the maximum punishment with the minimum amount of work. So that's kind of an overview of what they call the bureaucratic justice system. And then we have, another perception of the criminal justice system, and this is of Samuel Walker's wedding cake illustration. And this illustration is based on a model proposed by Lawrence Friedman and Robert Percival. And in this scheme, if you will, the largest portion of criminal cases kind of forms at the bottom layers of the cake, and the few more serious cases form at the top. And realistically, because the public is exposed only to the top of this wedding cake model, people develop a highly distorted perception of the system itself. And you can see, that the bottom ring or layer, if you will, kind of receive basic, mere token of the justice process. So, the more attention is going to be paid to the higher layers of the cake. So the celebrated cases, layer 2, the serious felonies, some of the lesser felonies, and then finally the bottom. But the bottom accounts for more cases, right? So this is kind of the wedding cake model of justice, if you will. Now we're going to kind of switch gears a little bit and talk a little bit about legal agent or moral agent. So many attorneys believe that loyalty to the client is paramount to their duties as a professional. And this loyalty surpasses and even eclipses individual and private decision making, and the special relationship said to exist between lawyer and client justifies decisions that might be deemed morally unacceptable. And others argue that attorneys should never abandon their own moral compass. And if the client desires some action that the attorney would, not basically, kind of countenance, if you will, ethics would demand that he or she convince the client not to do so. So, and historians kind of go a little bit further. Historians basically indicate that this dilemma has been problematic for lawyers since the first ethic codes were kind of written. So, what if your client wanted you to do something and the attorney knew that ethics demanded that he or she convince that client not to do so, not to do whatever they're thinking about doing, or maybe even withdraw from the case? Have you ever kind of wondered if you're representing somebody that you know is guilty, but you also know that they're lying to you? And how would you present that case, right? So, as we talk a little bit more about this conundrum, if you will, the conundrum of what to do when a client wants you to commit some act contrary to good conscience occurs both in civil and criminal law. And here are kind of a couple of different types of positions described and defined. So the first would be the legal agent model, which defines the lawyer as neither moral or immoral, but kind of merely a tool, if you will. So this position is represented by the statement, I'm a lawyer first and foremost. Next, you have the special relationship model. The lawyer places loyalty to the client above all other considerations. And that's kind of an interesting one, right? This protected relationship then justifies fewer actions than the legal agent relationship. The lawyer is expected to dissuade the client from taking unethical or immoral actions, but loyalty would preclude absolutely going against what that client wants you to do. And then finally, you have the moral agent model, the lawyer that must adhere to his or her own moral code. So the client's interests come first only if they do not conflict with the attorney's morality and ethical code. So if there's a conflict, the lawyer is going to follow their conscience. Okay? And Schaefer and Cochran in 2007 kind of they offer a slightly different typology, describing what we talk is the godfather, the hired gun, the guru, and the friend. So, the godfather promotes clients' interests above all others. The hired gun does whatever the client wants. The guru controls the client with his own moral compass as the guide, and the friend that engages the client in moral dialogue and tries to convince the client of a proper course of action and refuses only after the client insists. So those are some kind of interesting typologies as well, right? And here is a list of Cohen's moral principles for attorneys to follow. So, don't treat people merely as the means to winning a case. Treat similar people similarly, right? That makes sense. Don't deceive the court. Make reasonable personal sacrifices for those morally good causes. Don't financially support or profit from wrongful acts. Avoid harming others while representing your client. Be loyal to your client, but don't betray confidence. And make moral decisions. Act consistently upon those. And the rationale for these principles seems to be basically kind of an amalgamation, if you will, of ethical formalism, utilitarianism, and ethics of care, in that a lawyer should be concerned when the other side might be victimized or harmed by the actions of one's client, right? So a lot of good information, but these are Cohen's moral principles. So with every set of principles, there's going to be criticisms, right? And here are some. First would be they are naive and wrong on several counts. Existing rules already prevent unscrupulous acts. Decisions regarding justice and morality are so subjective that it's impossible for them to be judged. And a lawyer acting as a moral agent would forfeit client trust by substituting his or her own moral code for that particular client's code. So again, these are criticisms of Cohen's principles. And you can find these on page 246 and 247 in your textbook. Okay, so as we start to kind of finish things up, talk a little bit about ethics for legal professionals, talking about moral code of responsibility, model rules of professional responsibility, and even criminal justice standards. So formal ethical standards for lawyers and judges were originally promulgated by the American Bar Association in the Model Code of Professional Responsibility. And the original canons of this code, adapted from the Alabama Bar Association Code of 1887, were adopted by the ABA in 1908, and of course have been revised frequently since then. Now, in 1983, the ABA switched its endorsement of the model code as the general guide for ethical behavior to the model rules of professional conduct. And the model rules continue to be revised periodically, responding to changing sensibilities and emerging issues, because we do know that things change, right? So today's model rules cover many aspects of the lawyer's profession, including areas such as client-attorney relationships, the lawyer as a counselor, the attorney as an advocate, transactions with others, public service, and then maintaining the integrity of the profession as a whole. And that's from the ABA in 2015. So, take note that each state bar association can sanction offending attorneys or recommend suspension of their law license. And many complain that the bar associations ineffectively police their own ranks, just as sometimes individuals criticize law enforcement, saying that they sometimes can't effectively police their own ranks. And while law schools require ethics courses, many believe that in practice, those ethical considerations are in fact secondary. So some of the larger things to kind of consider then, well, when you have this client-attorney ethical conflict, if you will, when can the attorneys abandon their clients, or can they? So attorneys cannot abandon their clients unless the legal action is for harassment or malicious purposes, continued employment will result in violation of a disciplinary rule, they are discharged by that client, or a mental or physical condition renders effective counsel impossible. And to kind of go along with that, talking about that attorney-client privilege, prevents compelling attorneys to disclose confidential information about their clients. So if you know certain things as an attorney, and we know there's the attorney-client privilege, right? When can you actually release any information, or can you? So here are some exceptions that permit revealing confidence. And these include when the client consents, when required by a law or the court, to defend against an accusation of wrongful conduct, to prevent clients from committing crime or fraud, or to prevent or mitigate, meaning kind of reduce, or rectify financial injury to another. Because we know that attorney-client thing is a big deal. And what about judges then? Well, to help judges in their duties, the Moral Code of Judicial Conduct was also developed by the ABA, right? So there needs to be rules for kind of everybody, or at least moral codes to follow. So here are some ethical guidelines for judges. So first would be, and these are actually, they call them the 4 canons of the code. And these are right out of the ABA in 2017. So the first would be, a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Next, a judge shall perform the duties of judicial office impartially, competently, and diligently. Next, a judge shall conduct the judge's personal and extrajudicial activities, those outside of the norm, their normal activities, to minimize the risk of conflict between that outside stuff, if you will, and the obligations of that judge's judicial office. And then finally, a judge or candidate for judicial office shall not engage in political or campaign activity that is inconsistent with the independence, integrity, or impartiality of that judiciary. So those are some ethical guidelines for judges. So we want to finish up talking about culture and ethics. So the model code of professional responsibility dictated that lawyers should be temperate and dignified and should refrain from all illegal and morally reprehensible, kind of a tough word to say sometimes, right? Conduct, so bad conduct. The major subcultural pressure found in many law offices, including prosecutors' offices, that sometimes conflict with formal ethics is that culture of winning. And the other major theme in the legal subculture is the pervasive sense that all defendants are guilty, and this type of attitude then leads to cynicism and unethical behaviors on the part of both the prosecutors and the defense attorneys alike. Okay, so that kind of wraps us up. We're right ahead of that 30-minute mark, so that's actually not too bad. So this is going to conclude part 2 of our Chapter 8 lecture on law and legal professionals.